Humans are social animals, cannot live in isolation, and life is a long journey. One requires the hand of another to share their physical as well as emotional baggages. Marriage as an institution was shouldering the responsibility, but with the change of time, that is social, economical, and emotional changes, marriage is facing the challenge today. One of the elements for the success of marriage is trust, loyalty, and keeping this secret among the couples themselves. But with the change of time, the space required by an individual among the couple has widened, owing to the financial stability, emotional and psychological understanding, which marriage as an institution facing the challenges in the social dynamics today. In the third world countries, including India, young generation more inclines towards the live-in relationship rather than marriage. This scenario is more common in the urban zone than the rural. Young people are obsessed with the knot of marriage because of the dispute resolution mechanism and many other causes. Live-in relation offer everything what a marriage can offer. In the third world countries, the trend of live-in relation have increased in the recent decades, but the relationship in the developed and western world existing few decades back. The basic definition of live-in relation in the legal perspective is that it is an agreement among the unmarried couple who live together under same roof, sharing mental, physical and psychological as well as financial for the considerable period of time. It is a long-going relationship without legal knot of marriage. In short, live-in relation is the cohabitation between the two independent major unmarried person under one roof for a considerable period of time or permanently. In case of marriage, all countries had enacted laws, but with the emergence of the live-in relationship, various countries look towards it from the different legal perspective which need to be discussed for the better understanding. United States of America. In the last 1 or 2 decades, the statistics shows that there is the doubling increase of the live-in relationship in the American society. The various states in US has not come to the common point of law for which the prenuptial agreement among the live-in couple is taking place, but all the states does not want to enforce the agreement under law. The US society and law greatly recognize the institution of marriage. With the change of the social dynamics in US, the increase in the non-marital sex or cohabitation, the major states are agreeing on the prenuptial agreement where the financial matter, inheritance, parentage are mostly common. But the less states are still on the orthodox school of belief. The best reference can be given of the Illinois Supreme Court in Hewitt versus Hewitt case. Still, now the Supreme Court refuses to give judicial recognition to live-in relation. In Illinois. Australia. The law in Australia accepts the live-in relation as de facto relationship on the certain ground as mentioned in the section 44AA of the Family Law Act of 1975. 1. The relationship between the couple is that they are living together on a genuine domestic basis. 2. They are not legally married. And 3. They are not related by family. On that circumstances, the Federal Circuit Court or Family Court can deal with the dispute of finance, issues relating to children. Similarly, the Canadian law legally recognizes the live-in relation under Section 54, Clause 1 of the Family Law Act, RSO 1990. Further, if there is any such agreement to marry between the cohabitator, such agreement deemed to be a marriage contract. 3. United Kingdom. In Scotland, the Family Law Act 2006 provide limited right to the cohabitants. In Northern Ireland and Scotland, the unmarried father have the parental responsibility. In England and Wales, a consented couple can have sexual relationship if both of them are 16 years and above. In UK, the live-in relationship is largely covered under the Civil Partnership Act of 2004. The live-in relation couple are called the common law spouse. The purpose of the Civil Partnership Act is to obtain legal recognition in case of same-sex couple. In India, there is no statutory law in case of the live-in relation. The live-in relation in India is subject to the judgment forwarded by the courts, which act as the law. The step taken by the judiciary has been welcomed by the various quarters of the society. The courts in India have acknowledged the long-term live-in relationship as marriage in form of presumption in order to safeguard the interest of the parties in relation and children born out of such a relationship. The courts have never acknowledged the walk-in and walk-out relationship while safeguarding the interest of the parties. While safeguarding the interest of the parties, the courts had broadened the scope of the fundamental right under Article 19 and the right to life and liberties under Article 21 of the Constitution. As there is no codified law in the matter of live-in relationship, the judicial decisions act as the guideline. Let us now discuss the live-in relationship in India under the light of the judicial pronouncements. In 2006, Supreme Court observed in Lata Singh vs. State of UP and others that in live-in relationship between the two consenting adults of heterogenic sex does not amount to crime nor illegal, even though it may be immoral. Already, the Supreme Court has decriminalized the adultery in the judgment of Joseph Stein case. In 2010, the landmark judgment S. Khushbu vs. Kannimal, Supreme Court observed that live-in relationships are permissible of the act of two consenting majors. Living together cannot be called illegal. The Supreme Court goes further and states that live-in relationship comes within the ambit of Article 21 of the Constitution of right to life. While ascertaining the relationship as live-in, the Supreme Court held in the case of Madan Mohan Singh vs. Rajinikanth in 2010, the relationship, if not of walk-in and walk-out, but continued for a long period of time, then there is presumption of marriage between the parties. Similarly, in 2008, in Tulsa and others vs. Durgatia and others, Supreme Court observed that live-in relationship of 50 years can be presumed as marriage while reading the section 50 and 114 of the Evidence Act together. Law leans towards the legitimacy rather than frown upon bastardy. The Supreme Court has enlarged the scope of the term wife while granting maintenance. In Chanmunia vs. Virendra Khushwa case, Supreme Court upholding the right of a woman in the live-in relationship to claim maintenance under section 125 of Criminal Procedure Code. The notion behind the judgment is that the man cannot take the advantage of the loopholes of law of a de facto marriage. In another case, Indra Sharma vs. V.K.V. Sharma, the Supreme Court judgment act as the framework of the live-in relationship. While discussing the domestic relationship under section 2F of the Domestic Violence Act of 2005, decided which relationship will come within the umbrella of the proviso of the Act. In 2019, Supreme Court in Kamla vs. Mohan Kumar has interpreted the term wife and expanded the scope under section 125 of Criminal Procedure Code. While discussing the scope of live-in relationship, the judgment relating to the inheritance legitimacy of the child born out of the live-in relation needs special mention. In 2015, Supreme Court in Dhanulal versus Ganesh Ram affirmed the right to inherit the property after the death of the live-in partner. In this case, the family members of the deceased live-in partner contended that live-in partner was not the legally wedded wife of the deceased, so she cannot claim to inherit the property after his death. The Supreme Court viewed that where man and woman are living together as husband and wife, and law will presume that they are living together in valid marriage. In B. Matha versus V. Rengunathan in 2010, Supreme Court granted share to the parents' property in favor of the child born out of live-in relation. In another case, 2010, Madan Mohan Singh versus Rajinikanth, the Supreme Court goes further and decided that child born out of the live-in relation cannot be called illegitimate. So long we have discussed the decisions of the courts on the unmarried couple in live-in relationship. Now we need to move to the next stage where man or woman already married and not divorced by law and is in live-in relationship with another. Let us now see what courts approach towards this scenario. In 2016, Kusum versus State of UP, where a married woman left her legally wedded husband and entered into a live-in relationship with another man and cohabited with him for 5 years. The woman knocked the door of the Allahabad High Court for protection, but the High Court has turned down her application because earlier marriage was not legally dissolved. In 2018, Reshma Begum versus State of Maharashtra, Bombay High Court asserted that the domestic relationship under Section 2F of the Domestic Violence Act 2005 could not apply in case of adulterous relationship. The relationship between the parties was not in nature of marriage. The courts generally do not promote or to protect the adulterous live-in relationship. The married person, man or woman, in live-in relation will not receive any protection from law which the unmarried couple in live-in relation enjoy. Though in Joseph case, adultery section has been struck down, but bigamy case may be formed against the cohabitant. In many cases, courts had attracted bigamy section in place of protection.